Hey guys, it's Richard with BlueSheepdog.com here. I'm here to talk to you today a little bit about the three tiers of police and citizen encounters. So a lot of confusion about this. People that are not in law enforcement, regular citizens, generally don't have any real concept, most of them, with how this is, how this plays out. A lot of new officers coming through the academy kind of struggle with these concepts. And quite frankly, a lot of officers that have even been on the street for a while wind up having some confusion about some of these ideas. See a lot of case law that comes out on whether or not someone was lawfully detained or if someone was lawfully arrested. And a lot of it goes back to what we're going to be talking about today. So hopefully I'll cover some things, maybe make some things clear, and hopefully let you make some better cases out here. Okay, there's three basic tiers to a citizen police encounter. You have the consensual encounter, you have the investigative detention, and the last but not least, you have the arrest. Okay, and when we're talking about these three tiers, generally what we have is three different things that come into play for us. Is someone free to leave? What information do we need to affect one of these encounters? And then if we're interviewing someone, does Miranda come into play? So let's talk about these three things. First one, the least intrusive, is right here, the first tier, and that's the consensual encounter. And the consensual encounter is real simple. That's just me having a conversation with somebody. It could be I get out at a convenience store to walk inside to get a bottle of water, and while I'm standing in line, I'm talking to the guy next to me. That's a consensual encounter. Consensual encounter could also be maybe I see somebody suspicious, but I don't really have anything, any reason to stop them, but it just doesn't feel right. So I walk over and I start talking with them. Okay, consensual encounters. So in a consensual encounter, one of the primary things that we have to keep in mind is, are they free to leave? And absolutely, yes, they are free to leave. That means that if we walk over and we're talking with someone we think is suspicious, but we're not down here at the investigative detention, it's just a consensual encounter, and they say, screw you, I ain't talking to you, and they turn around and walk off, there they go. You cannot stop them unless you've got some reason to detain them, and we'll talk about this down here. But a lot of times, if you're starting up here at the consensual encounter, unless you've developed something more, you just have to turn and watch them walk off. Okay? Completely free encounter, they can talk to you, they cannot talk to you. Okay? If you're right here at the consensual encounter and you ask somebody their name and they lie to you, or they don't respond, they don't give you their name, they don't have to. Okay? If you're in a consensual encounter, you ask for their name, they tell you I ain't going to tell you, and you arrest them, you're going to have some problems in court. Trust me. Okay, so are they free to leave? Absolutely, yes, they are. What information do you need to initiate a consensual encounter? None. Okay? You don't have to have any specific information. You don't have to have a complaint. You don't have to have anything. You just happen to be in the area, they happen to be in the area, and you strike up a conversation. Okay? Like I said, could be just you're talking to somebody in line at the store. It could be you see somebody at the bus stop. They're not really doing anything unusual, but maybe it's a high crime area, and you kind of want to maybe just talk with the person, kind of feel them out a little bit. Could be that you're just walking in and checking on some business owners, or you're walking a neighborhood, walking an apartment complex, and you're getting to know people in the area. Okay, you have to. You don't need any information whatsoever to strike up a conversation with anybody. Last but not least, do you need Miranda? Nope. They're not in custody. They're not being detained. They're free to leave at any point, so you do not need Miranda. Okay, so this is the first level, just a consensual encounter. They're free to leave. You don't have to have any information to strike up a conversation, and you do not need Miranda. Okay, the investigative detention. Now this is the middle tier. Okay, it comes between the consensual encounter and the arrest, and this is the one that a lot of people wind up getting themselves in trouble. Okay, we're going to come back to that one. Let's hit arrest real quick. Arrest. Are they free to leave? No, of course not. They're under arrest, right? What information do you need to effect a lawful arrest? Probable cause, right? PC, probable cause. You have to have probable cause to make a valid lawful arrest. That or a warrant, right? And we're not talking about warrants. We're talking about just regular encounters. Last but not least, if you want to talk to them, is Miranda apply? Absolutely it does. You must read the Miranda if you're going to question them after an arrest. Okay? So the arrest, are they free to leave? Nope. What information you need? Probable cause. And do you need Miranda if you're going to question them? Absolutely you do. Okay. So now we're back at this middle point. Okay. Investigative detention. Now the investigative detention was something that law enforcement used, but it wasn't codified. It wasn't really recognized in the courts per se, along until the 1960s. And we had a little case called Terry versus Ohio. And in that particular case, a beat patrol officer, guy that knew his area, watched a couple of guys walking back and forth in front of a store. He recognized the behavior as being suspicious. He saw them walk back and forth past the store, kind of confer a few times, and then meet with a third party. And they wound up going past the store something like 24 times, okay, or 12 round trips. And they kind of met with this third party. The third party wandered off, and they kind of went back and forth some more, and then they met with the third party again. And the patrol officer, he stopped them to find out what was going on. He recognized their behavior as suspicious. They were targeting a particular store. I believe they were wearing overcoats, and maybe it wasn't terribly cold out. But the facts and circumstances that he was developing told him, looks like these guys are getting ready to rob the place. Okay, he was an experienced police officer. He wasn't just somebody straight out of the academy. He had experience. He had observable facts that he was able to articulate in court. And so what happened was we had the Supreme Court this case winds up making its all the way to the Supreme Court, and the Supreme Court, in an 8-1 decision, which is pretty good as far as decisions go, it was pretty clear that what the court thought. An 8-1 decision said that police officers have both the authority to stop and frisk people in certain reasonable circumstances, and that's what we're going to talk about. And that stopping of someone that does not constitute an arrest, but yet they're still not free to leave, it's going to be right here, the investigative detention. And that's what we're talking about. We're talking about our Terry stops, our investigative detentions. Okay? Stop and frisk. This is where we are right here. Okay? So, are you free to leave in an investigative detention? No, you're not free to leave. Okay? But what information do you need? Because if you have probable cause, you just make your arrest, right? So we need some level of information between probable cause and no information needed whatsoever. And that is a big loose area called reasonable articulable suspicion, or RAS. Reasonable articulable suspicion. And what that means is that you have to be able to articulate specific facts, specific behaviors that you know based on your training and based on your observations that the people there are engaged or about to be engaged or have just committed some type of crime. Okay? And it has to be reasonable. In other words, you can't come up with this bizarre set of circumstances to try to change the facts in your observations to match some reason to stop these folks. Okay? Reasonable. You know, are your facts reasonable to believe that somebody is getting ready to commit an armed robbery versus do those same facts you're kind of piecing together because you're trying to articulate that they're getting ready to steal someone's brain and turn someone into a zombie or something, okay? Something very bizarre like that, okay? So the reasonable aspect is what a reasonable police officer, what a reasonable man think that what you're observing matches the circumstances. Articulable, you have to be able to specifically articulate those individual observations and facts. Okay, and articulation, it's not just what you saw, but it's being able to recount that both in trial and also in your report. Okay, and then suspicion. Okay, something less than probable cause, but greater than just nothing or just a mere suspicion or mere hunch. Okay, if you see somebody you think is suspicious, that's going to be up here at the consensual encounter. If you see somebody you think is suspicious in a parking lot late at night, wearing all black clothes, carrying a crowbar, in an area that you've had problems with prior burglaries, the business is closed, okay, now we're talking about reasonable articulable suspicion. Can you articulate certain facts? Yes. Business is closed, it's after dark, subject's wearing all black, you've had problems with prior break-ins in the area, and the subject's carrying a crowbar. Okay, I can articulate those facts. Now, with those facts and my knowledge of crime, is it reasonable for me to believe that the subject is possibly engaged in a crime, or possibly getting ready to be engaged in a crime, or possibly has just committed a crime? Yes, the crime of burglary, right? Okay, so that's reasonable articulable suspicion. Okay, with RAS, if I can articulate this, then I can detain them and they will not be free to leave. The length of my detention is going to be only that amount of time I need to dispel my fears or to develop additional information to develop probable cause. Okay? An investigative detention is not going to be an indefinite period of time. Usually we're talking about the space of a few minutes. Could be a couple of minutes, could be as long as maybe 30 minutes or so. Sometimes a little longer. Generally it's going to be a little shorter. Okay, the longer you run your investigative detention, the more likely you're going to wind up down here at an arrest. Okay, we'll talk about that in a second. Investigative detention. Okay, so are they free to leave? No. What information do you have to have? Less than probable cause, but you need reasonable articulable suspicion. Does Miranda apply? What do you think? Well, maybe. Whether or not Miranda applies is going to be very flexible in this circumstance. Okay? It's going to be dependent upon a great many things, not the least of which may be some state laws and state rules that apply. Okay? Generally speaking, if you have just detained somebody temporarily and they've not been detained too long and there's no coercion and there's not a big show of police presence, they're not in handcuffs or anything, generally Miranda is not going to be necessary. Okay, notice I'm saying generally because it's this big continuum. However, if you have someone that's detained for a longer period of time, someone that's detained maybe in a patrol car, somebody that you've moved from one location to another without their permission, maybe you've got a bunch of police officers on scene, holding shotguns or something like that. You have the subject wearing handcuffs. In that case, Miranda probably is going to apply. The idea with Miranda is whether or not the person believes they are in custody. One aspect of it anyway. If the person believes that they are in custody and that they no longer have the freedom to leave, which I understand they don't, but if they feel like they've been arrested, then chances are Miranda will apply. If, on the other hand, they don't feel like they've been arrested, then chances are Miranda is not going to apply. So, if you stop somebody, in the example I just gave, let's say I stop that guy with the crowbar after hours and everything. I stop him, I identify myself as a police officer, he willingly stops, he puts the crowbar down for my safety, that kind of thing, and he and I are standing there talking. I don't have him in handcuffs, I don't have him in the back of a patrol car, I don't have a bunch of other officers around him crowding him or anything else. I simply explain, hi, my name is Officer Johnson, I'm with the police department, and the reason why I'm stopping you is it's after hours, kind of in this area we've had some problems, and you're over here carrying a crowbar. What's going on? And he starts talking to me. Chances are that's not going to be a Miranda situation. On the other hand, if I see the guy and he turns around, he spins around, he's got the crowbar in his hand, so I draw down on him, I order him down on the ground, and my partners get there, we get him handcuffed, we stick him in the back of my patrol car, and I go over there and say, hey, look, I stopped you because you're walking around this business after hours with a crowbar, and then you spin around and you got this crowbar. What's going on? In that case, is Miranda going to apply? Yeah, probably so. He's handcuffed in the back of my patrol car. He's had a bunch of cops pointing guns at him, right? Chances are he's going to believe that he is under arrest, and therefore he is probably going to need Miranda as far as the courts are concerned. Okay, big flexible area. It's not a huge thing that I'm trying to cover today with Miranda. I'm just trying to give you an idea of where Miranda is going to apply with the investigative detention. Now, you can move up and down this. If you almost think of it as like a use of force continuum, you can move up and down these three tiers. Okay. For example, I walk up, I start talking with somebody, I engage in a casual conversation with somebody at the consensual encounter. During the consensual encounter, I develop some information which causes me to have reasonable articulable suspicion of a crime. Maybe I'm talking with the guy, just casual conversation. We're standing in line at a drugstore, and during the conversation he starts telling me just kind of some bizarre things about his prescription medication, and that his doctor just kind of gives him prescription pads and he can kind of take care of things himself or something like that. Something that's not making sense to me. Okay, well, now maybe we've moved up here to the reasonable articulable suspicion that maybe he's involved in drug diversion, maybe he's involved in some type of prescription medication fraud, something like that. And then, during the course of additional investigation, I develop probable cause. I detain him temporarily. I go and I talk with the pharmacist. I call the doctor's office, find out the prescription pad's been stolen. The pharmacist says, yeah, this guy's been in here a bunch of times. I kind of confirm that with the doctor's office. Doctor's office, nope, he's not a patient. We haven't prescribed those medications. Maybe now I'm all the way up here to arrest. I've got probable cause. Off to jail he goes. Okay, so I've moved up. Can I move down? Yeah, absolutely. Let's say, for example, in the situation I was talking about earlier, the guy I think is committing a burglary, right? I get him detained. I stop. I start talking with him right here at the investigative detention point. Now, and I find out, hey, he's the business owner. He shows me his business card. He shows me some papers in his vehicle that he's the business owner. He's wearing black. Well, it just happened to be what he put on that evening. He had some tools at the house he was trying to return back to the shop because he wasn't going to be in for the next few days, but he knew the guys at his shop were going to need the tools or whatever. So I'm able to quickly dispel my fears that there's actually a crime going on. So now we're back down here, the consensual encounter. He's free to leave. Now, if he continues talking to me, and he's like, officer, you're right. We've had a bunch of burglaries in the area. Can you maybe give me some ideas about what I can do to make my property a little safer, a little hardened, or whatever? We're down here at the consensual encounter, right? We started up here, but we've moved down here. Likewise, we can even do that if, for example, the guy turned around, he spun around with the crowbar, and I thought he was attacking me. Do I have probable cause? Maybe. Okay, but certainly I'm detaining him. He thinks he's under arrest, or he's down here at the Miranda level, right? I Mirandize him, and he says, no, I'm the business owner. I'm sorry, it was a big misunderstanding and everything. We can move all the way back down. Okay, traffic stops. People ask, is a traffic stop is an arrest, or is it just an investigative detention? Generally speaking, a traffic stop is going to be right here, an investigative detention. Okay, you're stopping somebody. You may have probable cause for whatever the infraction was, or you may just have reasonable articulable suspicion. For example, let's say you're stopping somebody because they're weaving inside their lane. Okay, you follow them, they're doing under the speed limit, they're weaving inside their lane, they seem to be kind of lethargic at the wheel, they appear to be intoxicated. Now, under Florida law, I have not described any one specific offense that they've committed. However, I can put those together, develop reasonable articulable suspicion that the subject may be a DUI driver, right? So, make a stop right here at the investigative detention. Generally speaking, I stop the guy, he runs the red light, runs through a stop sign or whatever else. I go ahead and I stop him, start talking with him. We're right here at the investigative detention. Okay, and don't think they're under arrest. Okay, they figure that, okay, yeah, I've got to stop for the officer, but he's going to write me a ticket or give me a warning. I'm going to be on my way. So generally speaking, Miranda's not going to apply in those cases. You're going to have to look at your laws for your state. For example, some states are going to require, if you're doing a DUI investigation, that you read Miranda. Even though you're just right here at the investigative detention, state law may require you read Miranda, or case law may require that. Another example would be, in some states, if you're dealing with a loitering and prowling charge. The guy with the burglary suspect I identified earlier. Some states will require that I read Miranda first. It's codified in law. If it's codified in law, there's no way for me to avoid doing that. Okay, doesn't matter if they think they're arrested. Doesn't matter that they are or are not arrested. It's codified in law, so I've got to deal with that. Okay, investigative detentions, like I said, apply to traffic stops in most cases. So can I turn an investigative detention into a consensual encounter on a traffic stop? Maybe. Check with your local prosecutors, or review your local case law and everything, but a lot of times the answer would be yes. Give you an example on how and why you may want to do that. Let's say I stop somebody for speeding. Okay, they're doing 65 and a 50. So I pull them over for speeding. I'm talking with them. I'm developing kind of some suspicions about what may be going on in the vehicle. Okay, it's a rental car. They're not familiar with the area. They don't seem to have any luggage, but yet they're going on a long trip. Or maybe the spare tire is in the back of in the passenger compartment, making me wonder, well, what's in the trunk? So I'm talking with them, and for the purposes of my stop, I got all the information I need to issue them a ticket, but I've not developed anything other than suspicions. I have not identified a reasonable, articulable suspicion that they're involved in other specific criminal activity, allowing me to detain them further. Okay, now, you may be able to, based on what you see, based on what you smell, and the amount of other information you develop. But those things I've described, in and of themselves, are not necessarily, in most jurisdictions, going to get you to this point to detain them based on that. So, in this particular case, maybe I issue them the citation, and let's say I'm out on the highway, I have them come back from their vehicle, and we're standing kind of on the shoulder of the road, so we're not going to get hit. I issue them their citation or their warning or whatever I'm going to do. I give that to them. I tell them they're free to go. Sir, you're free to go. He turns around, he starts to walk away. I ask him, sir, would you mind if I asked you some more questions? Now, I'm not telling him he has to stop and talk to me. I'm asking him. And if he says, yeah, okay, sure, and he stops and turns around and comes back over to talk to me, are we at a consensual encounter? I would argue yes. It's not a definitive statement. Different prosecutors may tell you different things. But I will tell you that the prosecutors I've worked with, generally speaking, in those circumstances will back me up 100%, especially if I have it on video where I can show the subject freely and voluntarily came back over to talk to me. I didn't order him to stop. I didn't order him to come over and talk to me. I asked him, sir, would you mind if I asked you a couple more questions? He comes over, sure. What's going on, officer? And I say, sir, we see all sorts of weird things out here on the roadway, and I kind of noticed this, and this as we were talking. Do you have anything illegal in the car? Would you mind if I searched? Okay, those are all reasonable questions to ask. At no point have I told him he's detained. At no point have I told him, to move or to do anything else. I've given no orders. I'm still up here at the consensual encounter. Something develops from it, then I can say it was a consensual encounter. And many prosecutors will back me up on this. The key, though, is to know your laws, to know your state constitution, and know your prosecutors, and make sure that you're doing something that fits within the framework. Okay? You got to do the homework yourself on that side. But that brings me back to something that can escalate a consensual encounter into an investigative detention. And this applies not just on traffic stops, but anywhere else. And that is, when you stop asking and start ordering, you have just moved things from here to here. If I'm in a consensual encounter, I'm talking with someone, and they're moving or they're doing something that I don't want them to do for safety reasons, I can say, "Sir, would you mind?" Or, "Sir, sometimes I see weird things. Could you?" Or, "Sir, would you mind stepping over off the roadway?" Or whatever the case may be. As long as I'm asking questions and they comply, it's a consensual encounter. The minute I start telling them what to do, then I've escalated things into an investigative detention. For example, I'm here, I have no articulable suspicion that any crime is going on. And I start telling the guy, "Keep your hands out of your pockets." Well, now I'm giving him authoritative orders where you've just moved things up. On the other hand, I'm talking with somebody, he's making kind of some nervous gestures, putting his hands in his pockets. "Sir, for my safety, would you mind keeping your hands out of your pockets?" He complies, then I've just successfully got him to do what I want him to do, but keeping things at a consensual encounter level. Okay? Not only does it prevent things from escalating, but obviously it's also much better if the subject thinks, if it's probably just a regular citizen and not some dirtbag on the street, okay, not somebody that actually is involved in crime, they perceive you as being a little more polite, which isn't a bad thing, by the way. So there's our three levels. Some things that can also move your investigative detention up is into an arrest situation is the length of detention. If you got somebody detained on the side of the road and you're out there for 45 minutes or an hour, of course they're going to say, yeah, the person had a reasonable belief that they were in custody, that they were under arrest at that point. If you detain somebody, you've had a report of a particular crime, you see somebody matching description at a location nearby within a reasonable time frame, you stop them here on the investigative detention, completely valid. You tell them, all right, look, get in the car, we're taking you back over there for a show up. You drive them over there, you didn't get their consent to drive over there, you've just arrested them because you have stopped them and then moved them. Most courts are going to say that they were in custody. On the other hand, if you stop the guy here, you explain to him what's going on, and he willingly gives you consent, yeah, okay, I'll go over there with you. You load him up in the car and take him over there, chances are you're going to be fine. Generally, with those types of situations, we like to have the victim or the witness come to where you are and avoid the problem altogether. If you stop somebody here, have your victim or your witness come over with another officer, do your show up at this scene rather than taking them back to the crime scene. Generally, you're going to be a little better off with that. So things such as movement, things such as a time frame, handcuffs may or may not. Again, it depends on the circumstances. If you roll up to a scene, you see something going on, you throw somebody in handcuffs real quick for your safety, and once you've kind of got things stabilized, you take them back out of handcuffs and you continue your investigation. Is it investigative detention or an arrest? Probably just going to be the detention. But again, it's going to depend on all the circumstances. Has some force been used? Are there a bunch of officers standing around? Are there a bunch of officers with shotguns or rifles standing around? Are there a bunch of blue lights and sirens and everything going on? Does a person feel intimidated, coerced? Then it's probably going to be an arrest. But it's going to be a wide range of things. Okay, so these are our three tiers of citizen police encounters: the consensual encounter, the investigative detention, the arrest. Okay, there's a lot of case law on all three of these, especially when we're talking about the information that's needed and whether or not Miranda applies. Okay, Miranda is going to be no, maybe, and yes. The maybe is going to be the tough one. Okay, we definitely know that if they're under arrest, we need to read Miranda. We know that if it's just consensual encounter, then you don't have to. It's this big area right here in the middle that's going to trip you up sometimes. Okay, keep in mind that for the reasonable articulable suspicion, you're going to have something more than just time of day, or a person doesn't fit a neighborhood or something like that. If, for example, you're working midnights and your sergeant, your lieutenant says, look, I want a bunch of FIRs from you tonight. And for those that don't know, FIR, field investigative report, field interrogation report, generally it's little cards. Of course, we do it now in the computer system. It's just a brief, made contact with somebody in a particular area. You made a notation of who they were, what was going on. That way if a crime was developed later on, detectives could go back and look at those and see, oh, okay, these people were in the area at that time. Okay. If your sergeant or your lieutenant says, hey, look, we need a bunch of FIRs from you tonight, and you go out and you see somebody just walking down the street and it's after dark, and you force them to stop and talk to you, you do not have reasonable articulable suspicion. That is going to be a consensual encounter only. So if you try to stop the guy and all you've got is it's after dark and the sergeant told you to go do a bunch of these, if you try to stop him and he runs from you, you chase him down, throw him in handcuffs, carry him off to jail for obstruction of justice or obstructing a police officer, whatever you call it in your jurisdiction. It was really a consensual encounter. They were free to leave. You arrested them for something that you lacked probable cause for. You're going to lose the case, and depending, you could wind up in civil court on that. Okay, just because the sergeant tells you to go do a bunch of them doesn't mean you get to go and stop everybody. It means you can talk to a bunch of people to keep your sergeant happy. You may be able to develop reasonable articulable suspicion in some cases, but if you can anyway, you should be stopping them anyway, right, and talking to them. But anyway, those are the 3 tiers right here. If you've got any questions whatsoever, shoot me an email, richard@bluesheepdog.com. Visit our site, bluesheepdog.com. I've got a bunch of other information on citizen police encounters, on Fourth Amendment issues, search and seizure, and other things. So stay safe.